Thank you. Thank you so much for having me. Very happy to be here and looking forward to your feedback. So this is about personal liability. The big question that I'm trying to answer broadly is how to align corporate decision makers and stakeholders' interests, right? Like central question in corporate governance. A common approach, a common answer to this problem is offer gains, offer an upside. So you could think about like compensation, performance-based compensation, right? Like options, stocks, and so on, bonuses. If things go well, directors and executives get more. If things don't go so well, they just don't get anything. This paper is about offering or like imposing a downside through personal liability, so making them pay out of pocket if things don't go well. And it has been debated in recent cases. You may have heard the case of Mark Zuckerberg from Meta that avoided personal liability a year ago. PG&E executives were sued personally for California wildfire damage a few years ago. Okay, the question is, and the question that I'm asking broadly is personal liability a good idea? Okay, should personal liability be considered for directors and executives of firms to prevent them from misconduct? The trade-off, at least in theory, is on the one hand, it's certainly going to change incentives of directors and executives, right? Making them pay out of pocket is going to change incentives. And it's probably going to lead to better firm outcomes. On the other hand, it could be that it's going to exacerbate risk aversion. They may overreact in the firm's decision. And we may also be worried about them leaving boards, right? Like we may be worried that we will lose like the key valuable directors from the board. So this paper studies some of the key effects of imposing personal liability on directors and executives that I will detail soon. So the main challenge of imposing or like studying personal liability, and this is why it's mostly understudied so far, it is that first, the business judgment rule protects executives and directors in courts. And so basically to study personal liability, we need personal liability to change incentives, right? We need personal liability to change the perception of the risk of out-of-pocket payments by directors and executives. The business judgment rule does protect them in court. It's hard to sue them and to show that they should be liable. And even if they are, even if the court decides that they should be personally liable, the firm always pick up the costs in the sense that the firms indemnify them, so they pay legal costs, but also they purchase director and officer liability insurance on their behalf so that they don't have to pay anything. Importantly, we should always, understand this, that insurance companies have a legal duty to negotiate the settlement amount such that it is within the insurance coverage limits. Okay, so the settlement is negotiated such that it is within the insurance coverage limits. So there is no perception of out-of-pocket personal liability risk by directors and executives in a regular setting, which makes it hard to study. So I'm going to use in this paper a unique setting, which is corporate toxic releases in Canada. And the reason why I'm using this setting is that the liability is strict under environmental law for directors and executives. So there's no need to prove intent, knowledge, or negligence in court, which is the case under the business judgment rule. And also, the firm may not pick up the cost as much because those liability amounts are often really big, right? They may imply like cleaning up, but also compensating like victims, people who have cancer, and so on. It's often like dozens of millions of dollars, sometimes $1 billion or more. And on top of that, insurance companies that provide director and officer liability insurance do not cover contamination liability. It's not included into their insurance policy. So you may have watched those movies, Erin Brockovich or Dark Waters. This is exactly the type of pollution, contamination events that I have in mind. So the case that I'm going to use as like a variation in the perception of the risk of out-of-pocket personal liability, out-of-pocket personal liability in this paper is the North Star case. And the North Star case was a landmark court enforcement, right? So what I told you before is that the court doesn't protect as much like directors and executives for contamination. And also the firm doesn't pick up the cost as much because there's no insurance and the settlement amounts are large. This means that it's really up to the court to enforce out-of-pocket personal liability. Okay, so I'm going to use this case and I argue that this was a shift in the perception of this risk related to like contamination. So this company, North Star Aerospace, contaminated with chromium, which is exactly the same like contaminant that there was a problem in Erin Brockovich. And so they started to remediate in 2005, which the regulator was very happy about. And then they filed for bankruptcy protection in 2012 when the regulator was not happy anymore. And the regulator, so the Ministry of Ontario, which is where it occurred, went after the directors of the firm. And especially because a couple of directors were really rich, so they knew that they could get some money to compensate and to clean up. It ended up in a settlement between the regulator and the directors of the company in October 2013. So it was described as a wake-up call in the news for director and officer liability insurance companies. And I'm going to use this shift, like this court enforcement of out-of-pocket personal liability, and here I really want to emphasize out-of-pocket, as an exogenous shock to the risk perception of out-of-pocket personal liability because it was enforced. Okay, and I'm going to use like the fact that in Ontario they have a common law system, so similar to what there is in the US. And in Quebec, which is the neighboring province of Ontario, has a civil law system. And so basically, like first, they don't have the same like ministry, so they don't have the same regulator. But regarding the difference in legal system in Ontario, the common law system involves that court cases may influence like future court cases, while in Quebec, civil law doesn't. Like they basically don't look at previous cases or like in a limited way, and especially not cases from other provinces. So Ontario is going to be my treated group and Quebec is going to be my control group in a like defensive analysis. So you may think based on this case where North Star Aerospace filed for bankruptcy protection and then the regulator went after directors, you may think that this shift in the risk perception of out-of-pocket personal liability was limited to financially distressed firms. I did talk to some like legal experts in Toronto, where I did my PhD to try to understand that better. One of them said something that I found interesting. North Star impacted all businesses because it meant that directors and officers were at increased risk of having environmental orders issued against them when the company couldn't fulfill its environmental obligations. So the reason why it affected all businesses and not only the ones that are closer to financial distress is because there is so much uncertainty in how much the liability would be, right? Like there is some contamination and then we never know how much the liability, the payment of this cleanup is going to be. What's for sure though is that the regulator's main objective is to remediate and compensate the victims of the contamination. And so the wealthy directors and executives are more likely to be liable. So in this paper, first, I validate that the North Star case can be like used as a shift in the expected personal liability risk, that there was a change in the perception of this risk. And here I leverage the Canadian setting. In Canada, public firms do disclose about the director and officer liability insurance, which is nice because it's not common. In the US, they don't. So I collect some data for like the largest public firms that do disclose some good information about this. And that's like allowing me to see like whether the firms do purchase more insurance for their directors and officers. And then the key contribution of this paper is to quantify the effect of the case on toxic releases. So quantify the real effect in terms of toxic releases, because the liability was imposed for toxic releases and contamination, and study the margins of response, so how firms do change their toxic releases. This speaks to like potential benefits of imposing personal liability, right? And so here I use some data on toxic releases at the facility pollutant level that are disclosed by the government, like that are reported under a government program. And then the third thing that I do in this paper is to talk to the associated costs, right? Like, remember the trade-off of personal liability, right? Like it changes incentives almost for sure. But the big question is, what are the associated costs of like better firm outcomes? And so I look at like the shareholders' reaction, but also like the implications for corporate governance and board turnover. Okay, so it does contribute to at least two literature. The first one is the literature on personal liability of directors. And so here I want to emphasize that there is very few papers, at least empirical papers. We know the trade-off pretty well, but the empirical papers focus mainly on costs associated with personal liability. And here, so a paper that's pretty close is the Narayanan et al. Paper 2021, which was published in the JFE. And so they do look at like whether personal liability that was implemented in India like triggers the leave of independent directors. This paper is providing some evidence on the potential benefits of imposing personal liability rather than just focusing on the costs. And it also talks to the associated cost in this setting of the negative externalities. It also contributes to the literature on environmental policymaking. So how do we force firms to like reduce toxic releases and pollution in general? Corporate liability, so liability that is imposed at the firm level, is one common mechanism, right? The key obstacle to corporate liability is that firms are limited liability entities, right? So they can reduce the liability that they face by restructuring and going into a bankruptcy process. There's also some different types of mechanisms that we could think of, taxes, cap and trade, and so on. This paper is providing some evidence about another type of mechanism that could be used to address negative externalities of firm. Okay, so the first results are about like the effect of this North Star court case on director and officer liability insurance. And again, this is about trying to validate as much as possible the first stage. I use this court case as, or at least I claim that this court case is a shift in the perception of the out-of-pocket personal liability risk. And to justify this, I look at director and officer liability insurance data. So this data is mainly for public firms, right? Like, so for larger firm, my data on pollution is mostly smaller firms. So this is something to keep in mind. But basically here I regress the coverage of director and officer liability insurance on the interaction post-Ontario, where post is a dummy that equals 1 for the years following the year of the settlement. Thank you. And Ontario is a dummy that equals 1 for the firms that have headquarters in Ontario. And a control for like firms' characteristics. So you see that there is an increase in the coverage, the total coverage by 18%. So the increase is 18% over 3 years for firms in Ontario relative to other firms. And this can be interpreted as an increase in the total coverage indeed, but remember that this like DNO, director and officer liability insurance, policies often exclude pollution, like pollution liability. So it's more likely that this is about firms trying to add a side A difference in condition layer to their DNO liability insurance, right? Although this like side A difference in condition is always limited in coverage. From what I saw, they don't report always side A, so it's hard for me to do like a systematic analysis, but from what I saw, the coverage for this layer is about $1 million, which would be much lower than like any pollution liability. And so basically this increase in the coverage in director and officer liability insurance can be interpreted as firms sort of want to ensure perceived dyspnea risk, wants to ensure that directors and officers and increase the total coverage, whether it's from side A or not. So the main results are the effect on toxic releases. So here I have some data on pollution, like on different toxics. I mean, chemicals, toxic chemicals. I have about like 150 chemicals in the sample. The main outcome variable I'm interested in is the log of pollution. And I regress log of pollution on the interaction. So the same post-Ontario, where post is a dummy that equals 1 for the years following the year of the settlement, so 2013. And Ontario is a dummy that equals 1 if the facility, so before it was at the headquarter level, this is at the facility level, which is actually correct, more correct. If the facility is located in Ontario, and 0 if the facility is located in Quebec. I control for facility characteristics, what's happening at like the industry level, but also at the pollutant level, because again, I have a number of pollutants that are heterogeneous in their toxicity, the way they're measured, and so on. So this is the sort of first result on toxic releases. So we see that there is a decline in toxic releases in facilities that are located in Ontario relative to facilities that are located in Quebec. And the magnitude of this decline is about 23%, so it's big on average for 3 years. Okay. An interesting test that I do is to compare facilities that are owned by the same firm, but that are, so again, located in Ontario and Quebec, right? So I just add some year company fixed effect, and that allows me to compare facilities that are owned by the same firm, so like fixing firms' characteristics. I do find that the effect is even larger, 33% on average over 3 years. This could also reflect the fact that there is some reallocation of pollution from firms that have a facility in Ontario to the same firm that have a facility in Quebec, right? So this is sort of the next test that I do is to what extent this is reflecting reallocation. Is it really like decline? The 23% that I showed you first, is it really like a decline in toxic releases, or is it just like a reallocation, which is the main thing we worry about, right, in this literature? And so here I restrict the firms that do not have facilities in Ontario and Quebec. And in fact, in the paper, I also look at firms that have only one facility in Ontario, so they cannot send pollution anywhere. And I do find that the effect is smaller, but it's still, thank you. But it's still mostly significant, like statistically and also in terms of magnitude. So it does seem that firms reduce toxic releases and do not send it away. How do facilities reduce pollution then? Like, is it in the extensive margin or the intensive margin? Here, I'm going to have access to better data. In fact, for now, I use like hours as a proxy for outputs. And so I look at like the log of pollution, toxic releases scaled by hours of operation of the facility, and the log of hours of operation of the facility to have a better idea on the intensive versus extensive margin. And this shows that it's mostly driven by the intensive margin, so facilities improving environmental efficiency of their production rather than cutting down output. And this is, in fact, mostly driven by larger firms rather than smaller firms. So this is so far showing that imposing personal liability and of directors and executives leads to a reduction in toxic releases, and firms seem to be doing the right thing in the sense that they improve environmental efficiency of their production, either in investing into greener technologies or improving monitoring and so on. Now the question is, what are the costs associated with this decrease in pollution? First, what are the costs to shareholders? So I look at the stock market reaction around the settlement, the announcement of the settlement of the case, so October 28th of 2013. This is just an event study. This is plotting the buy and hold abnormal returns. And I normalize at T-1, so like on the day before the settlement. And we see that there is a decline in the buy and hold abnormal returns for the firms that are mostly affected. So this is only for the firms in Ontario in the manufacturing industry. And the magnitude is about 2.6% decline in the market reaction. So this is consistent with the fact that firms, or like at least shareholders, perceive that firms will bear some of the costs associated with imposing personal liability. The maybe more interesting potential cost that we may worry about, especially in a corporate governance audience, is what are the effects on boards? What are the effects on board turnover? So this is what I do next. I collect data from so BoardX, but also interestingly, WealthX, which is a database that is included into BoardX, that basically tell us about like who is wealthy in BoardX. So it's like a dummy variable in BoardX that tells us whether the director has a net worth greater than $5 million or not. For example, Neil Baker was like the main person who ended up paying in the North Star case, is considered wealthy in this database, which is sort of reassuring. And I merged this data set with my pollution data set to have an idea of where the facilities or the companies where those people are working at are located. Who do I care about? Well, the independent directors, right? Like the literature, the corporate governance literature is focused on the independent directors who have like a monitoring role and so an important role. The wealthy directors are also important because they're the ones that are most exposed to out-of-pocket personal liability. Remember that the goal of the regulator is to compensate and to find some money to pay the cleanup and compensate the victims. So they wouldn't go after directors who don't have any money, basically. And also look at directors with environmental expertise, thinking that they may get more scrutiny. So I follow, thank you. I follow what the literature has been doing, and this is actually very much still work in progress, but basically the main outcome variable that I look at is the ratio of the number of exits of directors scaled by the total number of directors on the board. And same, I regress it on the interaction post-Ontario that I care about. And so I find that there is some departure. So directors are more likely to leave corporate boards following the enforcement of out-of-pocket personal liability. Interestingly, I do not find that independent directors are more likely to leave. Wealthy directors, though, are more likely to leave following the enforcement of out-of-pocket personal liability, which is natural, which is interesting, and which deserves more research because we don't really know so far the role of wealthy directors, like to corporate governance and to firm value, which is sort of the next step that I need to work on. So just to conclude, this paper studies some of the key effects of imposing personal liability to mitigate environmental misconduct. And I have this setting in which the perception of this risk, out-of-pocket personal liability risk, presumably changed, which I use. And so there seem to be some environmental benefits. Firms reduce toxic releases, potential costs for shareholders, which is expected. And for governance, it needs to be basically more researched. But so far, the distortions seem to be limited. Independent directors are not leaving boards, which is interesting. It has strong policy implications, in particular for policy making, like environmental policy making, and also governance. And more research needs to be done. So I really look forward to Pat's discussion and to your feedback afterwards. Thank you.